Hi, everybody. So today we will go over the listing agreement. So let me share my screen. So this form is new as of June 24th, 2024. So let's get into it. So parties, this is who is part of the contract, right? It would be you as the seller and then my office, the broker, as the person in charge of helping you sell your home. And especially namely me. Property legal description, lot block and subdivision, also known as legal address. Improvements, anything that's permanently attached or built-in, stove, microwave, if it's a built-in microwave, dishwasher, disposal, TV brackets, okay, window screens, window blinds, what is it, curtain rods. It's all listed here. If you have any question about what doesn't stay, let me know. Basically, if it needs a tool to be removed, it stays, okay? Refrigerator, washer, and dryer do not stay. So you are free to take those unless you want to leave them. But if there's something else that you do want to take, make sure you let me know because we need to notify the other party, okay? Accessories, we talk about blinds and rods. If you have a pool, any pool equipment, any special controls. Also, if you have smart devices, alarm, Ring TV, cameras, solar panels. If you have solar panels, if they're leased or owned, you have to let me know. If you have a water filtration system, you have to let me know if it's leased or owned. Also, security systems, okay? Remotes for the garage, mailbox keys, those also stay. Anything you want to stay would stay here under exclusions. Is a house under a homeowners association? Yes or no? Listing price. This is a price that we will agree to list the house to sell for. Okay. And then this says the listing begins on this date and ends on this date. Now, this date we cannot enter until we're like 24 hours out from actually listing the property. Okay. Now, broker compensation. This is in bold because it needs to be reiterated and very clear. So realtors as a whole do not have fixed fees. We do not have a set fee. Everybody provides a different level of service and charges a different amount of commission. Now, I'm a full service agent. I charge 6% commission. I pay 3% to the buyer's agent and I keep 3%, or I should say my office keeps 3%. I believe in compensating the buyer for their work. The work that the buyer's agent does, it's very, very lengthy. It's very involved. And so, of course, they don't work for charity, right? Now, if you do not want to pay a buyer's agent commission and you only want to pay me, you have to understand that you are going to extremely limit the number of buyers that will be able to buy your property. Because if you do not pay the buyer's agent will have to charge their own buyer to pay that commission. Now, the buyer's already coming in with their own fees, their own loan fees, whatever the case may be. Even if they're cash, they have their own fees, okay? And if you do not offer to pay their agent, the buyer will have to pay it. And a lot of times they will not have the money to do that. So you have to understand that if you decide not to pay the buyer's agent, that you are limiting your ability to sell your property. It's basic economics, right? So in this A1A, I would put the 6%, okay? And then under A2A, I would put 3%. That's where I'm paying the buyer's agent. If you choose not to pay, this would be entered. But again, as I said, I do not believe in not paying the buyer's agent because every side needs to be compensated. That is a discussion we can certainly have at length if you're interested. Okay, now this says seller paying for buyer expenses. In addition to paying the broker's fees, seller may be asked to pay a buyer to contribute to amount to their closing costs. So if you choose to check B here, then this is where it says you can still negotiate to pay their commission. They may ask for help with closing costs. Now, we do not decide what the buyers in the market are going to ask for. The market will decide. So if it's a buyer's market, then they usually have a lot more to choose from. They have a lot more power in the negotiating because there's a lot more inventory, and then vice versa. Okay, so see paragraph 11F regarding authority to disclose. So we'll go over that in a second. This money is only earned and payable until we sell your property. Okay, now if you decide to breach listing, for example, last minute you decide not to sell the property and everybody's ready to go, then at that point, my brokerage may decide to talk to a mediator or maybe court. So let's hope we don't get to that, knock on wood, wherever that is, right? All right, payable. It's payable when you close on the sale. If you decide to sue the buyer, okay, and they decide, last minute not to buy, and you decide to sue them, then if you win, then you would owe us a commission. Also, if you breach the listing, if we've done all of our duties as the real estate company, and then you decide not to pay us, you still owe us a commission, okay? That's why everything is in writing. Broker's compensation is not payable if the sale of property does not close as a result of your failure, without your fault, to sell, delivery to deliver a clear title policy, your loss of ownership because you got foreclosed on or a legal proceeding, your failure to restore the property, let's say God forbid something happened to your house, or a previous condition set forth in the contract by the sale. Now, if the buyer breaches the contract, you can collect earnest money. But if the seller collects earnest money, the sales price or damages, that's where I talk about the lawsuit, then at that point you would owe us a commission. Service providers, us as realtors, we can collect referral fees from service providers. We just have to disclose it. I personally do not do that just because I don't believe in that. So we can collect other fees. If there's additional fees that we charge, we would enter that there. We would, of course, discuss it on a case-by-case basis. Protection period. So let's say our listing agreement ends. I've got 10 days to provide a list of people that looked at your property within 10 days. If any of those folks decide to buy the property, I usually enter 60 days here. If any of those folks decide to buy the property within 60 days after our listing agreement ends, then you would owe me a commission. However, if you decide to list the property with another agent, then you owe me nothing, okay? All monies are going to be paid in El Paso County. You authorize the title company to do the closing, handle the paperwork, and distribute the funds. This says that we will be putting it in the MLS with all the information, websites, IDX, all that good stuff. Now, I will check, broker will list a property with a multiple listing service, okay? If you do not want it on the internet, if you do not want it in the MLS, then we would check letter B. But why would you restrict yourself by doing that, right? This also says that if we do put it in the MLS, we have to do it within 5 days of this listing agreement. My personal policy is 24 hours, okay? The MLS requires the broker to accurately and timely submit all information. So if there's anything that changes regarding the property condition, you need to let me know so we can update it, okay? Now, subscribers to the MLS and appraisal districts may use this information to do appraisals. For example, your house sells, it'll show what it sold for. Then at that point, future brokers or appraisers can use that information to create appraisals for other properties. All right. Now, submission of information to the MLS ensures that persons who use and benefit from the MLS also contribute information. So it's a two-way street. Now, if you don't want it in the MLS, we would check number 2. Again, why would you do that? Seller acknowledges and understands that the property will not be publicly marketed. If you check 2, it will not be in the database for real estate agents or anybody that subscribes to it, or buyers that are looking in with their agents. Property will not be included in MLS downloads, and it goes on. So basically, it won't show up anywhere. Listing content. If the broker files this under 6A, the parties agree to the following. So 6A was here, MLS, right? So you agree, you understand that listing content is all the photos and information about the house. And then seller listing content means any information that you provide to us. Broker content is the stuff that we produce in connection with the listing. So seller grants us the non-exclusive worldwide royalty-free license to use the information from the sale of your house in further advertising. So once we sell the house, you give us permission to say we sold your house and use photos of it, right? The only thing we can't put is confidential information. All broker listing content is owned by us because we do pay to put that in there. You understand and agree that the information includes any changes to content be filed, okay? Now, authorization to access the property. That means you give us permission or any other person to enter the property disclosing who they are, any security codes necessary to enter, the use of a key. That's why we have lock boxes, or we'll discuss alternative things depending on your circumstances. To facilitate the showing of the property. You instruct us to access the property at reasonable times, authorize brokers, associates, inspectors, appraisers, and contractors to access the property at a reasonable times, and duplicate keys if we have to facilitate the showing. Of course, we will let you know, and whenever we're gonna access the property, of course, ask for your permission as much as possible. There's always the event that, God forbid, somebody's out of town and something, a neighbor calls and says, the water, house is flooding out of the water, right? Or water is flooding out of the house, sorry. My brain is trying to keep up with my mouth. So anyway, and then we can also engage in the showing of showing appointments. This says that you do authorize us to put a lockbox on the property. Only people that are authorized, it will be allowed to open up the lockbox. And then we will also know who showed it, what company, and what time and what date. Understand that there's always a possibility of unauthorized entry, theft, property damage, personal injury. That's whether you sell it or not, right? So neither the Association of Realtors nor the MLS requires a lockbox. So we can always make arrangements to show it, but just know that people sometimes call when they're outside the house or 30 minutes away or 10 minutes away. So the use of a lockbox is always more convenient. And of course, we will not authorize the use of it unless you give us permission. Now, if you have a tenant, you have to let us know because we have to coordinate with the tenant. Liability and an indemnification. So basically, we're saying that we cannot be held responsible for any claim from personal injury, damage, or other loss. We will do everything we can to make sure that everything is secure. But if you get burglarized or somebody falls in your house or something gets damaged, we cannot be held responsible. This comes with the territory, and it happens when you sell a property. So this paragraph 8, it says reserved. This is an old paragraph. It's being replaced with this temporary listing agreement due to the updates in the real estate laws surrounding compensation. So they left this alone because they didn't want to change the order of this, okay? Intermediary. This says that if another agent within my office comes and shows the property and brings us a buyer, then my broker will act as an intermediary. He cannot disclose information in either direction that's confidential or private, or give away anybody's position. In that situation, then I would be assigned to work for you as your agent. I would give you advice and opinion, and I would represent you. The other agent would represent the buyer. Okay. Now, if you don't want any agents in our office showing the property, then we would check intermediary. Again, that would be severely limiting your ability to show your property. All right. So if broker acts as an intermediary, can't disclose information either way, or how much money they're willing to give, may not treat anybody dishonestly, may not violate any real estate laws or the Real Estate Act. Confidential information stays confidential even after the sale of the property, unless given authorization in writing. And then broker will use reasonable efforts to sell the property, procure a buyer, and negotiate the sale. We cannot, of course, we cannot sign any documents for you or make any decisions for you. So if 6A1 is checked, broker authorizes the display of the information on the internet without limited use, unless you don't want it on the internet, or you don't want any addresses on there either. Why would you do that? But sometimes people want different things, right? So broker authorizes broker is authorized to market the property with these options. So you're saying that you will look at buyers that have conventional FHA, VA, cash, Texas vet offers. That's usually what I pick, unless you are in a position where you want to do owner financing, then we would check number 6. Owner financing is basically where you're acting as the bank. So D, in accordance with the MLS, this says what ways we are allowed to market your property: photos, video, for sale sign, furnish cooperative CMAs to protect prospective buyers, give out information that's not confidential to buyers, obtain any information from any loan you might have on the house, deposit earnest money, disclose sales price after the sale, respond to inquiries on the property, advertise during the listing, and then sold once it's been sold, place information in the MLS. Broker is not authorized to execute any document on your behalf. That's what we talked about before. Seller does or does not authorize me to share with other buyers or brokers that you will consider contributing an amount to a buyer's expenses. So that includes commission. So if you do authorize me to say that you are willing to pay a commission, then we would check does. If you do not want me to share that information, we would check does not. However, by not offering to compensate the buyer's agent, you are limiting your ability to sell the house. You have a much smaller buyer pool. Seller's representation. Seller has fee simple title. You own the house. You're not bound by another listing agreement. There is no pool, or if you have a pool or spa, you're going to keep it in compliance with ordinances. Nobody else has a right to lease or purchase a property or first right of refusal. You're current on your loans if you are not, and taxes and any association fees. If you are not, we would enter it there. You're not aware of any liens against the property unless you have a list, and we would enter it there. The property is not the subject to the jurisdiction of any court. All information is true and correct to the best of your knowledge. If you have a relocation company, we would enter it there. The seller listing content does not violate anybody's copyright laws. You're aware that if it's in a public improvement district or a municipal utility district, you need to let us know, because we do need to notify the buyer even before we get an executed contract. Okay. So if you pay any special extra fees a year, or you pay for either utilities or an improvement district, please let me know. You agree to cooperate in the showing of the property, not lease or rent without our prior written approval, not negotiate with any buyer, not enter into another listing agreement. If you become a checked promptly informed buyer in the event that seller becomes aware that property has been publicly marketed. If box 682, must be new, 682. See, 682. Okay, so if you see that the property has not been listed, let's see. Okay, if the box is checked promptly in the event the seller becomes aware this has been publicly marketed. If the house goes live before you give us permission to, you have to let us know. Maintain any, or you have to check to make sure it goes live when you agree to, right? Provide broker with copies of any leases or agreements, complete any disclosures, and if anything changes regarding the property condition, you need to let us know so we can add that to the seller's disclosure. Now, this says that if the house becomes vacant, you need to let your insurance company know, because they will need to be periodically checking on the house. If you do not let your insurance company know that it's vacant and you need to file a claim, then they may not just deny your claim, but they may remove your coverage altogether. Okay. We're not responsible or liable for any personal injury, your negligence, injuries or damages caused by other people falling or hurting themselves, other brokers who may have information on the property on their websites. So for example, Zillow. If Zillow has any information that's wrong on your house, please let me know. We do not own Zillow. We do not control them, but we do have the ability to request they change or correct the information they have. We're not responsible for acts of third-party violence, vandalism, or theft, freezing water pipes, dangerous conditions on the property, your non-compliance with any law or ordinance, or your negligence. You agree to protect, defend, indemnify, and hold up harmless from damages, costs, attorney's fees, and expenses that are caused by your negligence or your failure to disclose material information, or caused by you giving incorrect information to somebody. So please, 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 when you show the property, if you are there, please do not answer any questions regarding the property condition. Please have them reach out to me. So if we have any special provisions, we would enter it there. If the seller does not cooperate or facilitate the showing of the property, you are in default. And then we have the right to get compensation. Let's hope we don't get there. That's not the goal, right? Broker may also terminate the listing and exercise our remedies by law. If the sales price is not determined in the event of the exchange, let's see, if a sales price is not determinable in the event of an exchange or breach of this listing, list price will be the sales price for computing compensation. If the broker breaches the listing, broker is in default and you may exercise your any remedies at law. Mediation, if we have a disagreement, we agree to go to mediation first. We agree to the person who we're going to use and we share the costs equally. But if we wind up in court, the loser may have to pay the winner's attorney's fees. The other things that we will be adding to this will be information about brokerage services, seller's disclosure notice if it's applicable, lead-based paint if the house was built before 78. The T47, it's basically you saying what you know regarding this, any current survey you may have on the property. For example, if you have a house that has a pool and you have a survey that has that does not show the pool, we can use that survey to say, this is the old survey, but it now has a pool so that the buyer knows, so that the buyer can decide whether or not they want to ask for a new survey or waive the survey. But 99% of the time, the buyer will need a new survey. If it's in a municipal utility district, then we would check that. Or if it's in a public improvement district, we would check that. If you're part of an HOA, we would check that. If you owe any money on the house, on a mortgage, we would check mortgage information. The other things that we would probably check is insurance for buyer, seller, and that's it. The rest of and also authorization to disclose certain information. Okay, those will be in separate videos. This is an entire agreement. You may not change the agreement without everybody else agreeing. You cannot assign your legal responsibility to somebody else without everybody agreeing. It is binding upon you and your heirs and your administrators or permitted assignees. Together and separately, if you're a married couple or if you're two people that own this property together and separately, you are liable for the performance of it, of all the terms. Texas law governs the interpretation, validity, performance, and enforcement of this contract. If the court finds that any part of this contract is not legal, the rest of the contract is still enforceable. Any notifications must be done in writing. In accordance with fair housing law, we cannot discriminate. Broker advises you to contact your mortgage company to make sure that you owe what you think you owe. You have the right to review any information we submit into the MLS. I will send you a draft for your approval prior to submitting. Okay. Sorry, I got a little mosquito there. Broker advise you to review the information, remove any jewelry, prescription drugs, valuables, firearms, weapons, anything that is true to your heart or could cause damage to anybody, put it away. Okay. You have the right to consult with an attorney before using any kind of video recording equipment. So if you have anything that records audio or video inside or outside the house, you need to let me know. I do need to let people know. And you need to talk to your attorney about that because we may have a problem if you do have those and the people that are looking at your house do not know about it. A statutes ordinance may regulate things like swimming pools or if you have a septic tank. Non-compliance with it may delay the transaction and may result in fines, penalties, or liability to you. If the house was built before 78, there's probably lead-based paint. We have to give the buyer a copy of the lead poisoning pamphlet, disclose presence of any knowledge or reports you have or any records, and provide the buyer period up to 10 days to get the property inspected for those things. If the seller's a foreign national, then we have to notify the IRS and you have to check you are. If you're not a foreign national, we would check that you are not. The problem is foreign nationals have to pay taxes when they sell these properties. So we do have to let everybody know. Seller advises you to refrain from transmitting any personal accounting information. Do not email wiring information unless it's a request directly from the title company. And even then, you may want to pick up the phone and just call the title company to confirm that the email that they sent you was correct. We will probably send you one through our secure system. But if you get any kind of information from the title company saying that wiring instructions are changing, don't even answer that email, pick up the phone and call me. Okay. So broker cannot give you legal advice. Read this carefully. If you do not understand this entire listing or the effects of the listing, you need to talk to an attorney before signing. So let me know I know it's lengthy, but it's important to know everything up front. If you have any questions, let me know. Thanks. Bye.